Hello, everyone, and welcome to Crime in Court. My name is Heather, and this is voiceover only. I am recovering from hip surgery, just a little difficult to sit up, so there's that. Canton cover up series. This is the Commonwealth versus Karen Reed. We are going to be going over a brand new filing. So this is breaking news. The Commonwealth this morning filed a motion to exclude forensic data expert Richard Green's testimony from Karen Reed's second trial. And we're going to go through that filing, and we're also going to go through some of his testimony. So let me get my stuff already here. All right, so we're going to go through this. Like I said, this is going to be voiceover only, just, yeah. So bear with me, but you will be able to follow along in the filing here. So please hit the like button as we begin, and away we go. So already this is just infuriating to me. I didn't even have to read through it, and I became angry just by looking at the title. It says the Commonwealth's motion to exclude defense witness Richard Green's debunked opinions? I'm sorry, but I have to say something about this. Nobody debunked anything. Richard Green's opinions are relevant and science based, evidence based, yet this motion is so ridiculous on its face. It should never have been allowed. Judge Bev should rip it up into tiny little pieces in front of Hank Brennan's eyes and say, no, denied, because this is so dumb. They're going to, it is basically, as always, it should be expert versus expert. The jury is the finder of fact, and they decide who's telling the truth to the best of their ability, whose expert opinion they want to trust, what witnesses they think are reliable or not. So it is up to the finder of fact. But yet here we are with Hank Brennan, a few months from trial. We're supposed to go April 1st, so we got 4 months or 3 months um to get there. So um but 3 months out, and he's trying to get rid of her forensic data expert, which is ridiculous. And he already testified. He's already been qualified in a court of law to testify as an expert. And now we're going to question that? Okay, well, whatever. And he has no real reasons. And some of his arguments are really stupid on their face, like this first couple sentences here. So let's get started. I'm going to stop and I'm going to yell. Not yell, but I'm going to complain a lot about what he has to do or what he has to say here. So the Commonwealth respectfully moves this honorable court, I wouldn't call her honorable, to exclude the proposed expert testimony of Richard Green relative to two issues. Number one, the claim that Jennifer McCabe's phone Googled how long to die in sick or how long to die in cold. Those are the two different misspellings. The first misspelling is how long, and she spells the two with TI, and she spells cold CIKD. I call it sicked. That's how I pronounce it. And then how long to die in cold, or house long to die in cold. That's the S instead of the W in how. So those are the two separate misspellings that Jen McCabe did in her phone. As we know, this one, the sixth one happened at 6:23, and then the other one happened at 6:24. No one's disputing those, but it's the 2:27 a.m. search that Jen McCabe says didn't happen, and so do the not so qualified experts from the Commonwealth, and we're just supposed to trust them, which was Ian Whiffen, who, if you recall, I believe he had a British accent or something along those lines. And he used to work for Cellbrite, but he left Cellbrite and created his own app, which he says is better than Cellbrite, which no one's ever heard of. And Cellbrite is the gold standard that the FBI uses, everybody uses, law enforcement uses. Yet this guy, Ian Whiffen, comes along and he's like, I got this new app and this is the one that we should use instead. Hey, sorry, I know it doesn't sound like that, but that's pretty much what the Commonwealth is like doing to us, gaslighting us with this crap. So I'm sorry, I'm going to say some things and I'm not going to be totally nice about it. All right, so that was Ian Whiffen. And then the other expert that they put out was Jessica Hyde, who, if you recall, had the turban. She was wearing the wrap around her head. And she was very, I don't know, I don't really know what to say about her. Um, I don't know what to say about her and her demeanor and just the way she was on the stand. I get bad vibes from it. I can't explain it. I can't tell you why. It's just my intuition watching her on the stand and how she acted, how she spoke to the people that were asking her questions, whoever it was, Lolly, and it might have been David Unetti, I don't remember. She just was not very, um, I don't know, just something was off. And I just didn't believe her. She didn't seem credible to me. So there you have it. So it is up to the jury, the person watching the trial and deciding the defendant's fate, whether that expert has valid opinions or not. It is not up to the prosecutor to say, well, we don't like this guy's opinion, so we're going to tell you we don't want it in our trial. But that's exactly what he's doing. Anyways, let's get back to it. So the claim. Okay, so number one, the claim that those two searches happened at any time prior to 6:23 a.m. on January 29th. And number two, that Jennifer McCabe's phone incurred user deletions of any data related to Google searches. So remember, um, Richard Green also said that that Jennifer McCabe deleted her Google search of House Long to Die in Cold at 2:27 a.m. And we'll get to that in a second. All right, so exclusion is appropriate because both claims lack any evidentiary support. Are you kidding me? And the claims cannot be made in good faith. Again, are you kidding me? There is nothing wrong with Richard Green's claims. He has evidence to back it up, and it is made in good faith. And this is just a lousy excuse for we don't like what you've got to say because it hurts our case. So we're going to try to get rid of you and basically say you're a liar. Yeah, which is what they're doing. So, allowing introduction of baseless claims, here we go again with it. It's a baseless claim without any scientific, forensic, or factual support would be misleading to the jury and disruptive to the interest of justice. Yes, misleading the jury would be disruptive to the interest of justice, and that is exactly what the Commonwealth is so good at trying to do. So we're going to let's look at this statement here. So, baseless claims without any scientific, forensic, or factual support. Okay. Remember that company called Cellbrite that does cell phone extractions that is the golden standard for all law enforcement and FBI? FBI is law enforcement, but I wanted to make sure that, the federal government also uses this extraction. So basically, to say that this Cellbrite report is wrong is really the controversial take on this, not the other way around. So what the Commonwealth is saying is what is controversial, not what Richard Green is saying. So, anyways, let's take a look at this. This is the Cellbrite report from Jennifer McCabe's phone of the 2:27 a.m. search. This is Cellbrite. Remember? Cellbrite says this. It's not Richard Green who just comes up with this out of the blue. He didn't just come up with it, out of thin air. He actually got it from this Cellbrite extraction. So let's take a look at it. As we can see, timestamp here is 2:27 and 40 seconds in the AM. Source, Safari. So she did this search on her Safari app on her iPhone. It's an Apple iPhone. The value. What did she search? House long to die in cold. This is the HOS spelling for how. Was it deleted? Yes. I'm not a forensic expert, okay? But I can read this report and tell you that the search happened. I don't need to be a forensic expert to tell you, look, this Cellbrite report says it happened. I can read it myself. A fourth grader could read this and tell you that it happened. Just to continue on and be fair, we also have this is the same thing, Cellbrite report from Apple iPhone, 6:23 and 51 seconds in the morning. This is the how long T die in sicht. She spelled the two and the cold wrong. Was it deleted? No. Nope, it doesn't say yes, so therefore it was not deleted. Because if you look up top, it says yes, specifically says yes if it was deleted. So if not deleted, it's a negative. Just no data in that space. So therefore, it was still in her phone records, not deleted. Next, 6:24 and 18 seconds in the morning, she does the second search of house long with the HOW, no W, S. So HOS for house long. And then was it deleted? No. So these were in her phone records for sure because she had to explain away somehow the 2:27 a.m. search, which she did, which I believe she opened the app, searched it, realized her mistake almost immediately and closed the tab. And now she's like dying on the hill that I never made that search because she deleted it quickly and didn't actually look at the answer, perhaps. But realizing she made the mistake, and maybe she did look at it, I don't know, but realizing she made the mistake, she knew she had to cover for it at 6:23 a.m. and that is what she tried to do, but the first search she searched it misspelled a second way, with the TO being spelled TI and the cold being spelled CIKD. To cover for that mistake, she had to then search it again with the OS, the HOS, house. As you can see, it makes perfect logical sense the way I just explained it, and with meaning these were a cover up, and the other one happened earlier on. So I'm not making it up. He's not making it up. These are actual extractions from a third party, which is used for phone extractions across the board for legal proceedings. So there's that. And yeah. So again, who's misleading the jury? I wonder. All right, moving on. The Commonwealth's expert, Ian Whiffen, is Cellbright's senior digital intelligence expert and an expert in digital forensics. So what does Cellbright, or what does this footnote have to say? Cellbright is the leading forensic extraction software tool. Well, look at that. They admit that Cellbright is the leading forensic data extraction software tool. So wouldn't they allow for that data to be correct? Instead, they're fighting tooth and nail to tell you that Cellbright is wrong. Yet, right here, they just said it's the standard, basically. It's the leading forensic tool. It's the leading forensic tool that provides forensic examiners the ability to access and analyze data stored within a digital device. The Cellbright software allows an examiner to parse layers of data through different methods of extraction and analysis. Perfect. So now we know that the Commonwealth does acknowledge that Cellbright is pretty gosh darn accurate, yet they're going to tell us something different. He has engaged, so Ian Whiffen, is the guy with the accent and his own app that he broke off from Cellbright and said, I'm going to create my own app, and nobody's ever heard of it. He has engaged in a comprehensive analysis of the two above claims lodged by Mr. Green. His analysis has included the implementation of forensic data. So he's doing an analysis of Mr. Green. Well, I get okay, so of his claims, I guess. That never mind. All right. I was thinking like he was, but he is. He's trying to correct him, or he's going back and looking at this, whereas it just I don't know. Because Mr. Green made the claims, now they're going back and trying to debunk it. So, to use their own term. His analysis has included the implementation of forensic data science, personally reviewing the data, the device data properly and accurately, employing Cellbrite technology. So they just said he properly. Oh wait, Ian did this. Sorry, no, Ian did properly and accurately, employing Cellbrite technology and a study of materials generated from the device. This, by the way, is a footnote to nothing. There's no footnote there. Just calling it out like I see it. So, after a comprehensive study by Ian Whiffen of the data and consideration of Mr. Green's claims, Mr. Whiffen's opinions disproving Mr. Green's claims are unequivocal. This is bullshit. I'm calling it right now bullshit. And this is hyperbole, and a lot of judges don't like that. They don't like when you are, when you use language like unequivocal and disproving, because they didn't disprove anything. These are two different hypotheses, theories, two different experts that came to two different conclusions, and it's up to the jury to decide who's reliable and who isn't. But that's just my 2 cents. All right, moving on. Mr. Whiffen provides, quote, I can state with absolute certainty that there is no evidence whatsoever on the device that the Google searches occurred prior to 6:23 on the 29th of January 2022. So the night in question, he says he can tell you with absolute certainty, which I don't even think you can't do that. First of all, like technically you can never say absolute or 100% certain in a court proceeding because no one can ever say that. But you can perhaps say, I've come to a reasonable degree of certainty or something along those lines. There's probably like a specific set of language that they have to use legally for that to work in their testimony, but they can't they can't say an absolute certainty. Like if he said that on the stand, it should have been struck. Like they should have objected and it should have been struck from the testimony. But yeah, so he says that he says with absolute certainty, which is a bunch of BS to me. So moreover, Mr. Whiffen concluded that there is no evidence that the user tried to delete any search history or the tampering occurred with any of the data I examined. Well, then what is this? How did Cellbrite, if there's no evidence, how did Cellbrite come up with this record here? I wonder. Hmm, interesting, huh? Consequently, Mr. Green's testimony on the two issues is wrong, factually unsupported, and shouldn't be admitted at trial. Really, it's not up to Mr. Brennan to decide if it's wrong. It's up to a jury. Again, he's taking all of this should never Judge Bev should rip this up and never talk to Hank Brennan again. This is ridiculous. Like that should be his punishment. Actually, his punishment is that he should only be in Bev's courtroom uh, when he practices, but that would be more of a punishment. All right, so the underpinnings of Mr. Green's testimony on these two issues fails to meet the requirements set forth in Daubert versus Merrill Dow Farms Inc. and Commonwealth versus Lanigan because one, the defendant cannot meet its burden to demonstrate that Mr. Green is qualified to testify to these two opinions. Okay. Two, Mr. Green's opinions do not meet the minimum requirements of digital forensics and lack any scientific basis. And three, Mr. Green will be unable to provide any facts to support his previous testimony. You mean facts like this? He's not going to be able to support or to provide any facts to support his testimony, which has been completely discredited relative to these two issues. No, no, it hasn't. This is not Brennan's place to say that. This is absolutely improper and I think unethical. I think it's borderline unethical of a prosecutor to, well, the arguments he's making here, some of them are completely untrue and ridiculous. And for that reason, he should be fined or something. He's sanctions. I don't know. All right, procedural history. On January 21st, 2022, Mr. Green testified on behalf of the defense. Mr. Green purported to be a forensic expert specializing in computer cloud surveillance systems and other systems. Mr. Green testified that he was asked to parse through data from phones belonging to Jennifer McCabe, Karen Reed, and John O'Keefe. He said the Google search was found in the write ahead log, where data is stored temporarily before it is written into the main database. Mr. Green claimed just by the nature of it, we'll find a lot of new artifacts in the wall file. There's a lot of talk about the wall file. And I don't know, I'm not techie. I don't understand all the technical language and whatnots, but it something had to do with this wall file and interpreting it in a certain way, and that's how I don't know. But for whatever reason, that wall file is really important. Mr. Green also proclaimed that the search was in a deleted state because she deleted it. Yeah, she deleted that search because she realized what she did and she was like, whoa, gotta delete that before the cops see. But oopsie, Cellbrite found it. Mr. Green testified he testified that he found a lot of other user deleted artifacts in Jen McCabe's data from the morning. Okay, so what? What does that have to do with anything? Who cares? He did find other things that she deleted. She deleted several things. She deleted a whole bunch of stuff that happened in the morning when she deleted the 911 call and a bunch of texts and things, calls that were happening that morning. But Cellbrite got it. Just um, because she deleted it doesn't mean that it's gone forever. All right, so on April 11th, 2023, Richard Green submitted an affidavit on behalf of the defendant opining that search history information obtained from Jennifer McCabe's cell phone indicates that on January 29th, 2022 at 2:27 and 47 seconds in the morning, the phone user entered the following search in Safari: the house long to die in cold with the S. And that is another footnote. See Richard Green's affidavit. Okay. On January 21st, 2024, Mr. Green testified at the defendant's first trial and rendered a similar opinion claiming that certain phone details were user deleted. During cross-examination, Mr. Green was broad and vague about his training, experience, and lack of digital forensics certification. So we're going to go through the very beginning of his testimony to kind of see what he says about that. Mr. Green conceded during his trial testimony that Cellbrite modified their software based on his misinterpretation of data. That's not what he said, and these are like this is them spinning words. So it's probably like he conceded, well, yeah, there have been Cellbrite updates since I did my analysis, but I still stand by my analysis. The updates shouldn't change anything. If anything, you're going to get more information from the information that I already had. So he could dive deeper into it. If Cellbrite keeps doing modifications, he might be able to dig deeper into that little file piece of information and figure out definitively something, that it may have happened or not. But he's saying I remember that he said on the stand, there's been updates and you can get more information with each update, but yet that doesn't mean the same thing that this sentence means, which is he admitted to misinterpreting the data. That's not true. And then it says, despite knowledge of his error, Mr. Green has yet to submit a revised written report or opinion. What does he need to revise or opine about differently? His opinion hasn't changed. If he does more of an extraction, maybe. But why would he need to? Like whatever. Okay. In response to Mr. Green's misconstructions, the Commonwealth retained two experts in digital forensics. That's the Jessica Hyde, the turban lady, and Ian Whiffen, who had his own app that he was pushing on the stand. During the defendant's first trial, the court permitted a courtroom demonstration by Mr. Whiffen to assist the jury in understanding digital forensics and how the Google searches were stored within the digital databases, specifically the Safari Internet browser. Additionally, Jessica Hyde, a highly qualified forensic examiner, conducted an encompassing review of digital artifacts, file systems, and conducted independent peer-reviewed experiments to determine that Jennifer McCabe's phone was in use at 2:27 a.m. when the Safari browser was open and looking at a website for Hockomock Sports at 6:23 a.m. The same Safari browser tab was engaged, and a new search for how long was conducted when Apple produces a suggestion for how long to digest food. The search is instead completed with how long tea die in sicked. So this is the second misspelling that she does of the day, and that's at 6:23 a.m. A new search is conducted at 6:24, which is the first misspelling because she first misspelled it at 2:27 a.m. and then she did it again at 6:24 a.m. The finding was consistent with Trooper Garino's review of the cell phone extraction and his testimony. Okay, Trooper Garino. Let's talk about him. He missed 32,000 text messages on Sandra Birchmore's phone between her and Matthew Farwell, and I'm going to say alleged because he's not convicted yet, but her alleged KILLer. 32,000 text messages between the two. He was grooming her. He was essaying her since she was 15 years old that we know of. She was 22, right? 23. 23, I believe, when she passed away. And so the grooming and everything combined was about a decade of SA, CA, grooming, whatnot. And so yeah, there were 32,000 text messages between the two, and yet Trooper Garino missed them all. So what does that say about his expertise and whether he's reliable or not? I say no, thank you to Trooper Garino. I say we put him back on the stand though and get him to perjure himself once again, and maybe he can go to prison for some perjury, and um, maybe I don't know if you can go to jail for being a bad cop that misses information, but you certainly can be put in jail for a bad cop who hides or lies about information that would put away a fellow cop and help find justice for this poor girl. All right, moving on. Cellbrite has updated. Did I read that? No. Argument. Richard Green's debunked opinions, they're not debunked, are not an example of a battle of the experts best left to be resolved by the fact finder, but instead an attempt to infect the jury with an inadmissible opinion that is not premised on reliable digital forensics. How is he going to support this argument in court, I wonder? I want to know how he's going to support that. Infecting the jury with an inadmissible opinion. They're so loud. That is not premised on reliable digital forensics. Like, what? Okay. Cellbrite has updated its software to prevent manipulation of data. Shortly before the defendant's first trial, Cellbrite created and introduced Physical Analyzer software version 12.2. Since the defendant's first trial, Cellbrite has added another version of updated software 7.67. The updated version removed the timestamp value from records sourced from the Safari's browser state.db because further research shows that the timestamp is not a reliable source for the timestamp relating to the URL shown. Well, I'd like to see that in, wherever he's getting this from, I'd like to see proof of that because I don't buy it. Basis for where's his scientific proof for this? The basis for Mr. Green's contested opinions has been refuted not only by the Commonwealth's independent experts, but by Cellbrite itself, who has removed the type of timestamp relied on by Mr. Green from Cellbrite's decoding engine. If this is true, then this needs to be reviewed and it needs to be looked at further because there's a problem then with that data and it needs to be looked at even closer, which you'd probably find that, again, that it did happen. Further, when Jennifer McCabe's cell phone extraction is analyzed in the newest version of Cellbrite, the 2:27 a.m. last visited timestamp no longer appears on the extraction report. Rather, the time shown represents the status of the browser tab and digital forensic artifacts pertaining to web history, and Apple Mobile Safari again confirm that the house log to die in cold search occurred at approximately 6:24 a.m. Likewise, yeah, it did. It did. No one's refuting that. But it also was at 2:27 a.m. and was deleted. Here he's saying, likewise, there was no evidence that the Google searches were user deleted, which is BS. We know she deleted a whole bunch of stuff. That's ridiculous that they're even arguing this. Even though Mr. Green's claims are wrong, that's not for you, Mr. Brennan, to decide. The defendant herself has engaged in promoting this false narrative in a June 27th, 2023. Of course, now here they go, blaming the defendant again. They're blaming the defendant for something the McAlberts did. The McAlberts, all this time, energy, money, taxpayer dollars, anyone who lives in Massachusetts should be outraged that your tax money is going to this nonsense. They're trying to put away an innocent woman and strip her of all of her defenses, all of her experts, and call her a liar on top of everything. I'm so sick of these people. I really cannot stand them anymore. Where is that FBI? Come now, please. Take them out. They all need to go. Everyone in Norfolk County. This is so ridiculous. I told you it was a ridiculous filing. So, in June, there was an interview with Gretchen Voss. The defendant advanced this baseless claim that he says. So Karen Reed says, first court appearance after we revealed that Jen McCabe, Ms. Little says, Googled. Mr. Yannetti says, yeah, defendant says, and it happened at the same time as the basketball search, which also wasn't in the report, nor was the how long to die at 6:23 that she admitted to. So there were other things missing from the report, not just the first 2:27 a.m. search when they received the report from the Commonwealth. There were no Google activity in the Cellbrite report that was handed over to us as gospel. And then there's a redaction. And that's from the transcript of Gretchen Voss. So now that they got that, they're using it in a court filing to say, here, look, she's lying about something, or she did this, or she did that. No, it's not a lie because it happened. Inadmissible evidence should always be excluded. Allowing debunked claims to reach the jury would necessarily risk misleading the jury and creating prejudice to the Commonwealth The role of expert testimony is to assist jurors in interpreting evidence that lies outside their common experience. Mr. Green's factually wrong opinions would not assist jurors and would instead risk confusing jurors. Bullshit. All right, law. An expert witness is not permitted to testify to matters beyond an area of expertise or competence. Okay, keep that in mind. Commonwealth asserts that Mr. Green is not qualified to render an opinion, claiming one, that Jennifer McCabe's phone Googled how long tea die in sick or house long to die in cold at any time prior to 623 or 623 on January 29th, 2022, and that two, any claim that Jennifer McCabe's phone incurred user deletions of any data. A Daubert-Lanigan hearing is necessary to assess whether the defendant may call Mr. Green to testify to these two debunked claims in her second trial. So now they want another freaking Daubert-Lanigan hearing. So let's waste Karen's money some more. Let's have her fly out her experts, fly out her attorneys, have them, hold them up at a nice hotel, and, more money that she's got to spend on these people. She's got to feed them, I'm sure it's quite pricey to do these things. There you go. All right, a Daubert-Lanigan hearing is necessary, blah, blah, blah. No, we're not going to do a Daubert-Lanigan hearing. That's what I say. But who knows? We'll see. Judge Bev might say, oh, yeah, Daubert-Lanigan hearing does sound good, even though he's testified already. Same as Dr. Russell. So it is the defendant's burden to establish that Mr. Green's testimony will assist the trier of fact to understand the evidence or to determine a fact in issue. It is a fact at issue whether or not the 220 search happened, right? I mean, this is the thing. You guys are arguing it did or it didn't, and we're arguing that it did. So obviously, that is what his testimony is for, to help us determine an issue of fact. And that the methodology or theory underlying the expert testimony is sufficiently reliable to be presented for the jury's consideration. Clearly, the methodology or theory underlying Mr. Green, clearly? You didn't even go into what theories or methodology he did. You just said clearly his methodology is wrong. Well, what did he do that was wrong? Tell us. He didn't do anything wrong. He read the Cellbrite extraction that gave him that information. There's nothing wrong about it. Blame Cellbrite. Ask a Cellbrite expert to refute it if you have a problem with it. Clearly, the methodology or theory underlying Mr. Green's testimony is not sufficiently reliable to be presented for the jury's consideration. How do you figure? You haven't argued one bit what theory or methodology he's done that isn't going to be helpful or that he shouldn't have done. Anything that was incorrect that he did. A jury should not be permitted to consider baseless claims. The defense will not be able to meet the Daubert-Lanigan standard required to proffer Mr. Green as to the two contested opinions. Who are you to say that the defense will not be able to meet the standard? F off, Hank Brennan. That is what I say. Get bent real hard. Because this filing got me outraged. For the foregoing reasons, the Commonwealth respectfully requests that the court order a Lanigan hearing or exclude Mr. Green's opinions relative to the two contested claims at trial. Absolute BS. Let's go back to the affidavit of Richard Green before we listen to his testimony from the first trial. So here we go. The first bullet here on his affidavit. I am a data forensics expert with United States Forensics LLC, hereinafter USF. I am a certified computer examiner with the International Association of Computer Forensic Examiners and hold certificates in this is his expertise. This is why he's an expert in cybersecurity, computer crime investigations, digital forensics, and computer investigations, AS, whatever that is. So, right there, you can see he is qualified in the very things that he is utilizing to come to an opinion: the digital forensics, computer investigation, computer crime investigation, cybersecurity, all those things come into play as to looking at Jennifer McCabe's phone extraction and determining whether that search happened or not. So I would say he's qualified there. But what do you guys think? All right, so let's move on to, oh, hold on one second. Okay, sorry, I wanted to get the captions on and everything. So here we go. We've got, we're gonna watch a little bit, not all of it, but we're gonna watch a little bit of Richard Green's testimony at the Karen Reed trial. This was June 21st, 2024, and away we go. Let me turn the volume up here.
Michigan.
What do you do?
I own and operate a company called United States Forensics.
And what is United States Forensics?
Sure, we're a digital investigation firm. We're licensed in Florida and Michigan, but we do cases across the country.
All right, and again, I'd ask you to keep your voice up only because we have an air conditioner there and we have jurors behind me.
Okay, I'll do my best here.
Yeah, as best you can. Now, you are president of that company, sir?
I am.
In addition to managing the company, what do you do on a day-to-day basis?
Well, I perform the majority of the investigations. I specialize in computer, cell phone, cloud, auto video, metadata media, surveillance systems, things of that nature.
President of a forensics data company, and those are all the things that he does. Like, why? How is he not qualified? He's the president of the company, and he does the extractions and the analysis himself, along with others. But he himself does it also. So why is he not qualified?
Work in conjunction with others.
Certainly.
Describe that, please.
Certainly. Well, we do take cases from individuals. Well, prefer to take cases from attorneys. We've also worked with numerous public defenders. We've worked with a federal public defender. We've worked with law enforcement. So quite a variety of clientele.
Civil cases?
Yeah, civil and criminal. I would put it about 60% criminals, 40% civil.
Okay. And on the criminal side, you've done both law enforcement and defense, correct?
Yeah, most of the law enforcement ones, though, have been more geared towards civil. It's when they had perhaps they were party to a suit, and it was just improper for them to use their own experts. So that's where we've provided assistance.
Now, how long have you been involved in the field of data forensics?
Sure. Well, my first case and testimony was 28 years ago. I'm not even sure we called it data forensics back then, but that was 28 years ago, and then about 16 years ago.
So he's been doing this for 28 years. So how's he not qualified?
Started the company United States Forensics and been full-time in the industry since that point.
All right. Now, you'd mentioned that you'd actually testified for the first time 28 years ago. That would have been 1996, if my math is correct?
That's correct.
You were qualified as an expert witness at that time?
Yes, sir.
In order to have been qualified as an expert witness, you must have had experience before that?
Yeah, specifically in computers. We didn't do much with cell phones.
So he's been qualified as an expert in court before this time. So it's not like this is his first time testifying.
Back then, by about a decade or so in computer IT, networking. We actually built a line of computers, a lot of repairs. So I was pretty deep into the computer IT world at that point.
Okay. And you say you formed your company in 2006?
Correct.
And do you work full-time, part-time? What's your schedule?
It's been full-time ever since.
Would you describe for the jury, please, your educational background, your training, certifications, etc.?
Why don't we break it down into smaller segments?
Sure.
Okay.
First, with regard to the training that you've received.
Sure. So that would have to do with Associates of Digital Forensics.
Well, that would more be your education, right? You received an associate's degree in digital forensics?
Correct.
Okay, so why don't we start with education, since you did?
Okay. Well, that was part of the work and more or less the formal training to get that degree. The certifications, which again, this all kind of goes hand in hand, but the certification training would be the CCE, which is certified computer examiner from the International Association of Criminal Investigation Specialists. I also have a certification as a computer crime related investigator, cybersecurity, as well as computer first responder. The training aspects over the last 18 years on really a daily basis, when I've worked, I've participated in listservs, done research into the newest developments in the computer forensics, and really on usually a weekly basis, we'll target some training seminar. I found in this business, even if you took us like 6 months off, you would start to get behind in this business. It changes that rapidly, and you really need to do continual training.
Okay, and again,
So he just sat there and talked about how he's done continual training. Like, I'm sure, professional development quarterly, he probably does something. He's probably required with all of his certifications to keep up his training because that's usually how it goes. So, um, he's constantly training, but yet Brennan doesn't think that he's qualified. And also, I'd like to say, Brennan, I don't think watched this trial. He admitted it in one of the hearings, but I don't think he actually has a full understanding of this trial or how the law works either, because this is crazy. Just some of the crap that he's done already, being as he's taken over the case from Lolly. So it's just really bizarre. But anyways, let's keep going. But do you see he's got training, he's got certifications, he's got an education, he has the formal education, the associates, and then the certificates is really where it's at because those are the specialties. That's where your expertise comes in. That's the certificates. So that's more important than the actual formal in some cases. Anyways, go on.
voice trailed off a little bit at the end, so
I'm sorry.
I'm sorry to keep reminding you, but I just want to make sure everybody hears. With regard to the amount, your caseload at USA Forensics, can you give the jury some idea of how many cases you handle on a yearly basis or have handled historically?
Yeah, we average, I'd say between 100 and 120 cases a year. We probably get inquiries to about 3 times that amount.
Okay. And have you testified as an expert witness in the area of computer forensics since that 1996 first
Yeah,
appearance?
we testify about 2 dozen times in various state and federal courts.
Okay. And when you say various states and courts, is that state court, federal court, both?
Both.
Now, directing your attention to September of 2022, were you contacted by somebody to become involved in this matter?
Yes, sir.
Remember who that was?
I believe it was Ms. Little.
What were you asked to do?
Well, there were 3 cell phones related to this case, and to provide relevance with the data on those phones as it related to the incident on January 29th, 2022.
Okay, and were you aware of the owners of those 3 phones?
Certainly. It was Karen Reed, John O'Keefe, and Jennifer McCabe.
Now, I'd like to ask you first, if I can, about John O'Keefe's phone. How did you receive the data from that?
All right, sorry, I had paused it there. And now I skipped us ahead to where we're going to start talking about Jen McCabe's Google searches.
To switch, if we can, to Jennifer McCabe's phone and your analysis of that. During the course of your examination, when you reviewed data from her phone, did you find a particular artifact of interest?
Yes, I did.
What did you find?
We found a Google search that happened. First of all, the search was how long to die in cold, and it happened at or before 2:27 a.m.
All right. Where was that search found?
Sure. So the artifact on that was called a Safari Suspended Tabs artifact, and there's a database associated with that called the Browser DB database, and in a company file, which is by the same name but ends in WAL, which stands for Write Ahead Log. And the write ahead log is where the data first gets written to, and then at certain points, that data then gets committed and written to the main database.
All right. So that, if I'm correct, that browserstate.db/wall file, that's a temporary file, right?
It's temporary by nature, but it's not. It's integral. It's part of the way the SQLite functions. So it's not like a throwaway file. It's part of the way the whole system works.
And is it helpful to you when evaluating artifacts?
Certainly, yeah. Just by nature of it, we'll find a lot of the newest artifacts in that WAL file.
Now, how do you determine the timing in terms of the timestamp on the browserstate.db WAL file?
Sure. So the WAL file has different rows and columns. You can kind of think of it as an Excel spreadsheet, and in this one particular column had it was a time column. That'd be the nature of the data going into it, and this the heading on this particular one was last viewed time.
Okay. Regarding that Google search for HOS long, and I say HOS, HOS long to dry and cold, found in the browser state DB WAL file, what was the date and time for that artifact?
Sure. So that's recorded in what's called Apicocoa time, and it's actually the number of seconds since January 1st, 2001. So you end up with this large number, but that gets converted to present to us something that's human readable, and then you have to apply the offset for the local. So once you do all those calculations, that's where we get the January 29th, 2022 at 2:27 in the morning.
The specific, do you remember the number of seconds after?
I believe it's 40 seconds.
2:27, 40 seconds.
Yeah.
Okay. And in what state did you find that artifact?
Yeah, so the specific artifact, or it comes from a record, and the record number on this is 4028, I believe, and it was in a deleted state.
Okay. Now, what would you normally expect to find along with the artifact, sir?
So you'd have the date and time, the URL, which the way the URL presents itself, we know that it's a Google search, but you also see a history of other places that tab has been.
And with this particular artifact, did you learn the full internet history of websites related to that record?
No, that wasn't possible. We were only able to get the one website. I would say. I'm sorry. Go ahead.
I interrupted you. Sorry.
Well, no. So we definitely got the one artifact, the Google search, and we have the time related to it, but we do not know everywhere else that tab had been.
What significance was there to you about the fact that the full internet history related to that record could not be recovered?
Well, I wanted to do a little deeper dive into that, and so I used some various other database specific tools. One was called Belkasoft X, which has an excellent database viewer. And
So I'm just going to interject here and say, so it's not like he just took the Cellbrite extraction information. He did his own kind of analysis and extractions and things where he used his own softwares and multiple tools in order to try to see, patterns and things like that. So he definitely is experienced. He knows what he's doing. He did it in multiple ways, multiple tools, and yeah. So I don't think Hank Brennan has watched the trial, but this hurts them, so they have to. And who's paying for all of this? Taxpayers. Taxpayers are paying for Brennan to try to exclude this guy and to come in again for a Daubert hearing. Except, Karen's going to have to pay for her people to come in, but the Commonwealth still has to, it still costs them money to run a hearing. So we'll see. We'll see what happens. Hopefully, Judge Bev says this is ridiculous. And of course, he can testify, but I have a feeling she's going to grant a Daubert Lanigan hearing.
at Sanderson Forensics, which is known to specialize in this type of work. And
ArtX?
I'm sorry?
ArtX?
You saved me. Yes, ArtX, which is a program known in the community for research.
And how did you sort of cross-reference the three of those together? How did you use them?
Yeah, so all three of those tools, along with Axiom and Cellbrite, which I did, they do have a low-level SQL viewer as well. So I looked at the data with all five of those tools, and I found it to be consistent amongst all the tools.
And in addition,
Consistent amongst 5 different tools. Is that what he said? 5, right? 3.
And Cellbrite, which I did, they do have a low-level SQL viewer as well. So I looked at the data with all 5 of those tools, and I found it.
All 5 tools. So the 3 that he just said, and then the Axiom and Cellbrite, all consistent across the base.
To be consistent amongst all the tools.
and in addition to using those tools, what else did you do?
So I want to get a little more context. One thing with this artifact, it is deleted. And one thing about deleted data, sometimes you get it all back, sometimes you don't, sometimes you get a fragment. Deleted data makes it very difficult to give you the whole picture of what's happening. So in this particular case, I wanted to see what other artifacts were around this time as it related to web history, and particularly this browser database file.
And so, what do you compare the 2:27 a.m. search to in order to gain more information?
Exactly.
I'm sorry.
What the information was. So what we found is that when we looked at a particular URL, a particular website that was visited, and then searched using that URL, the browser state database entry is the last entry in all of that. So we could see searches, videos playing. There's an artifact called knowledge C that records the user's activity, but the browser state is the very last entry on the items that we observed.
And did you find other examples of that you can speak to before this jury?
Yes, I believe we have one printed out there.
Okay. May I approach, Your Honor?
Yes.
I placed the document before you, sir. If you could familiarize yourself with that and look up at me when you're done.
I have it.
What is it?
Okay, so this is another screenshot from the Axiom program, and it is showing a search that we conducted for raining men, and then it takes that search, and we have a couple different items on there. We set the date to begin in 1970 and ending in 2100. In other words, we only want to see artifacts that had dates associated with them, and then we listed them from the newest date to the oldest date. And this particular one, again, it ends up with the Safari suspended tabs artifact being the very last in the series of dates and times.
All right, I'd like to go through that, but first I'd offer it into evidence, Your Honor.
Okay. Any objection?
No, Your Honor.
I don't remember this. Do you guys remember this?
Okay.
Here, could you explain to the jury what's going on with that exhibit?
Certainly. So I'm gonna switch glasses back here. Forgive me.
Do you need the light on, sir, or are you okay?
No, I'm fine, Your Honor.
Okay.
Thank you much. I can certainly do this. So we are looking at here web-related history, and also I have the filter turned on for application usage because there's some log files, sort files that the iPhone keeps track of to record user interactions, and that can give us a idea of the history as well. And then, as I mentioned, we have it filtered so that's only showing dates, that dates existed, and we took the earliest possible date to a date way in the future. And then it's listed, and next to the date and time, you'll see a little arrow, and it's skinny at the top and big at the bottom. That tells you it's going from smallest, earliest time to latest time. And this particular view is showing us the last of that series, because what's relevant and really important here is that the Safari suspended state tabs ends up being the last of the entries related to that, not one of the beginning of the entries related to that.
And what is the significance of the Safari state tab being the last entry? What does that tell you?
Yeah, well, so it tells us that internet history happened before that, and the purpose of this tab on at least this particular iPhone with this very specific iOS version is to record the state of that tab when the user left that. And the whole purpose of that is if you're on Safari, you're on a website and say you have to take a phone call or answer a text message and you navigate away from the Safari app, when you come back, it remembers where you were and allows you to pick off from there. It also allows you to hit the tab button and see what other tabs you might have open and navigate to one of those tabs.
All right, so as I see the last tab, am I correct that the time is 1:29:22, same day, at 2:27 and 38 seconds? Is that what it says on your?
I'm sorry. I'm definitely getting a pair of bifocals. I apologize here. I feel a little silly. Yes, on this particular one. So that is just moments before.
It's really hard to read, but it says last interaction date slash time 1/29/2022, 2:27 and 38 something a.m. Safari suspended state tabs. Okay, that's what that says. I can't read what the title says there. It's kind of cut off.
For the Google search artifact.
The one that you previously talked about, the How Long to Die in the Code.
How long to die in the code, yes.
But all the other history of this particular artifact was before that time, correct?
Correct.
So with regard to what that tells you about when the It's Raining Men was either searched or accessed, was that at after or before 2:27 and 38 seconds?
I'm sorry, can you?
Sustained.
Okay, well, if you say it one more time.
All right, let me try and put it a different way. Given the timestamp of 2:27 and 38 seconds on January 29th for that Safari suspended state tab with the It's Raining Men, what did that tell you about the timing of when It's Raining Men was accessed by the user?
Yeah, well, so the indications would be that that tab was brought up and then went away from to do another tab. So it can happen less than a second. It doesn't take long to open up a tab and start a new tab. Can be done very quickly.
I'm not really phrasing this the right way to get
Okay.
what I want. What I want is the timing of the interaction with It's Raining Men by the actual iPhone user. When did that happen?
Well, certainly, all the activity that we have is all prior to the recording of this that timestamp in the browser state.
All right, now, with regard to
So the tab wouldn't have, basically, he's saying the tab would have ended with whatever was the last, or when she went to go open it, it would have had the last thing she had on it, which is, common sense, but not, I don't know.
this particular example where the browser state DB is the last entry, so the activity happened before, was that unique on this phone, or were there many examples of this?
No, I found many examples of this exact behavior.
All right. Now, given your findings in researching these issues and how this user used this iPhone with this iOS, do you have an opinion to a reasonable degree of scientific certainty as to the timing of that search for how long to die in cold?
Objection.
To a reasonable degree of scientific certainty,
Sustained.
and she sustained it when he objected.
Do you have an opinion to a reasonable degree of scientific certainty as to when Hosslong to Die in Cold was searched?
Objection.
Sustained. I can see you at sidebar.
Thank you.
What the F, Judge Bev? All right, sidebar. Hold on. Let me skip through it.
Do you have an opinion as to the timing of that first search for Hosslong to Die in Cold?
Yes, I do.
What is that opinion?
That would have happened at or before January 29, 2022 at 2:27:40 a.m. in the morning.
And what is the basis for your opinion?
Again, by how this particular phone operates with that exact operating system and comparing it to other data on that phone and the way it presented it out itself is all consistent with that search happening at or before that time.
And what opinions or conclusions did you reach regarding how, if any, how the 2:27 a.m. search was deleted?
Well, we know that that's in a deleted state. And importantly on that phone is I keep using the proverbial we, I found a lot of other that would have been used or deleted artifacts between midnight and the early mornings on January 29, 2022.
Okay. Are you aware of any internal mechanisms that could have caused that deletion?
No, not in this particular case. I know of no mechanism that would have done that.
And you mentioned other deletions on the phone. I want to show you what has been marked, if I may approach. Sure. MMM for identity.
So, okay, by the way, I don't think that the Commonwealth is denying that these things were deleted because they're being shown as deleted, but, well, except for the 2:27 a.m. search, they said that didn't even happen in the first place, but the other things that were deleted that morning, like her 911 call, so if it wasn't user deleted, according to Hank Brennan, none of it was user deleted, how did those things get deleted? It was just a freak accident? Come on now. That would be insane and too much of a coincidence, and I don't buy it.
Identification. Do you recognize what I've placed before you, sir?
Yes, sir.
What is it?
Okay, this is from Cellbrite. Is a program again like the Axiom that processes data, and this is a this lists out a 623. This lists out a deleted call record.
Okay. Are you able to see from that record to whom the call was placed?
Yeah, well, we have the number, and I won't necessarily read it out loud here, but through searching, and this is from the phone of Jennifer McCabe, but through searching for that the number, I was able to see that it went to. You want me to say the name?
Sure.
Yeah, Uncle Brian A.
Oh.
Brian Albert.
I would offer that into evidence, Your Honor.
Same objection as before,
So those are this is what has been deleted from Jen McCabe's phone records. A phone call to Brian Albert that morning.
Your Honor. As when this was, may we approach?
Okay.
Okay, now another approach. Hold on, let me skip us through.
Thank you. May I approach again, Your Honor?
Yes.
Another report generated out of
Final document before you, if you can identify that for the jury, please.
Oh, sorry, I thought I paused.
There's one final document before you, if you can identify that for the jury, please.
Yes, this is another report generated out of Cellbrite. It's based on Ms. McCabe's cell phone data, and this lists out the call log with a number of deleted items and number of live items.
I would offer that, Your Honor.
If I get to see.
Sure.
Get in evidence. We look at the exhibits that were specified. So, first page of that.
This is basically
with regard-
the Cellbrite extraction, I believe, that we've already gone over, so I don't think we need to go through that testimony, but so there you have it. I think he's pretty qualified. What do you guys think? Let me know in the comments below, and I will see you guys in the next one. Thank you so much for watching. Take care, and Happy New Year, guys. Bye now.